Good morning, members, and welcome to this meeting of the Dumfries and Galloway Licensing Board. This meeting is being recorded. Could I remind members to follow the good practice guidance, which includes muting microphones and switching off their video when you are not addressing the meeting. Should you wish to contribute to any item, you should write "speak" in the Teams chat function or raise your virtual hand and you will be invited to speak in order. Should your question or issue be raised by a previous speaker, please withdraw your request so that we deal with the business as efficiently as possible. Members may notice that when calling members to speak, I will refer to them using the formal title of Councillor Smith example so that it is clear who are councillors and who, by the process of elimination, are officers. Now move on to item 1. Sediment and apologies and convener's approval. Mr. Tom, can you provide the sediment and any apologies, please?
Thanks, Convener. Present today, we have, in addition to yourself, members online: Archie Driver, Councillor Ian Howie, Councillor Kim Lowe, Councillor Stephen Thompson, and Councillor Jackie McCammon, all online. Apologies from Councillors Beretti, Dorward, Inglis, McGregor, and that's everyone.
I approve of members' remote participation. Declarations of interest. Do any members have any declarations of interest they wish to make? Councillor Dryborough.
Thanks, Convener. It's not a declaration of interest. It's to say that I have got a COVID and pneumonia jag at 11:24. I'll be able to get this on my phone as I walk up there.
Right, thanks for that. If there's no other declarations, we'll move on to item 3. Minute of meeting 18th of September. Can we approve this minute as a correct record?
Happy to approve, Convener.
Agreed.
No dissent. Move on to item 4. Licensing Scotland Act 2005. Applications granted under delegated authority. This item is here for noting and gives details of number of applications granted under delegated authority. Are members happy to note this item?
Noted.
Right. Noted. Move on to item 5. Licensing Scotland Act 2005. Application for new premises licence. This item is for dealing with an application which has been received for a variation of premises licence. Clark, can you go through this report and confirm the procedure for this item, please?
Thank you, Convener. Yes, this is an application for a new premises licence, so the board has to hold a hearing in respect of this application. In addition to the report, we have the application itself, an LSO report and a layout plan. The procedural requirements were complied with. The application was sent to the relevant authorities at paragraph 2.2 of the report. Advertisement was made appropriately and the site notice requirements were displayed properly. We've got confirmation of that. In terms of the decision for members today, the board must consider whether any of the grounds for refusal apply. If no ground for refusal applies, the board must grant the application. If any of the grounds for refusal applies, the board must refuse the application. So in terms of what the grounds for refusal are, starting at paragraph 3.3 of the report, firstly, if the subject premises are excluded premises, whether there's a ground for refusal under sections 25, 64 or 65 of the Act, those are just to remind everyone, I suppose, that there has already been an application for this matter refused in the last 12 months. That's section 25. Section 64 is the presumption against a 24-hour licence, and section 65 is an application for off sales either before 10 a.m. or after 10 p.m. The other relevant ground for refusal would be having regard to the licensing objectives. The applicant's not a fit and proper person to hold the licence. Further grounds for refusal, going down page 14, would be that granting the application would otherwise be inconsistent with one or more of the licensing objectives which are set out there. Whether the premises are unsuitable, having regard to the nature of the activities proposed, the location, character and condition of the premises, or the persons likely to frequent the premises. And finally, is whether the board considers there is an over-provision. In terms of procedure, we do have Licensing Standards Officer Mary Irving, who has drafted a report. I imagine Mary will be able to speak to her report first. We also have the applicant, on behalf of the applicant, is Victoria Baird, who's here in the room today, who can speak second, speak to the application and be asked questions. And then there can be summing up afterwards. We also have a police officer in the room today, Amy Ritchie, should the police wish to have any comment. There haven't been any objections from the police, but we do have Sergeant Ritchie here. After everyone's had the opportunity to speak and be asked questions, there can be summing up, and then members can deliberate and decide whether there's a ground for refusal. If there is no ground for refusal, then the application should be granted.
Right, then we'll go through the procedure. Just seeing as you're here, Sergeant Ritchie, take it there's nothing you wish to add to this application.
No, Convener, thank you. Nothing to add.
Ms Irvin, would you like to speak to your LSO report, please?
Yes, thank you, Convener. As a bit of a background to this one, the premises were licensed under the 76 Act and transitioned under the 2005 Act until the licence was surrendered in October last year. As in my report, this was done without the knowledge of the licence holder. During this period, the premises have never came to the attention of the board, albeit there has been 6 different licence holders within that time. All times, activities and admittance of children and young persons proposed within the operating plan are all within the board's policy. The notice was displayed correctly with no issues. I've got no negative comments to make. Thank you.
Are there any questions for Ms Irvin at this point? I don't see any hands going up. Right, now Ms Baird, would you like to speak to your application?
It's just to say that myself and my partner own the building and we have done for 12 years, and as Mary had said, the previous tenant surrendered the licence without our knowledge, so I'm just here to hopefully get it back and get the pub back open for the community, which has been well missed over the last year.
Any questions for Ms Baird? Don't see any hands going up. Usually go to summing up, but I don't think there's much to add. If you're, with that, we'll go straight to session. Members, we've been asked to look at this licence. I've got Councillor Thompson, then Councillor Howie, then Councillor Dryborough.
Thanks, Convener. It was just to approve the licence. I think it's straightforward, and it's probably better to get it through. Thank you.
Councillor Howie.
Thanks, Convener. Very much the same as Councillor Thompson. I do know that the community are supportive of this application being granted, so I support Councillor Thompson's motion on that.
And Councillor Dryborough.
Exactly the same, Convener. Happy to approve.
Anyone otherwise minded? Don't see any hands going up. Take it that'll be a unanimous decision to approve. Mr Tom, could you reflect the decision?
Thank you, Convener. The decision of the board unanimously was to approve the application. The licence be granted. You'll receive confirmation of that in writing, Ms Baird. Thank you.
Thank you very much.
Now move on to item 6. This item is for dealing with 2 applications which have been received for variations to premises licences. Mr Tom, can you take us through this report, and we'll deal with them individually. Tina Mara first and then Sam Booker second.
Yes, thanks, Convener. Again, this is a case where the board has to hold a hearing. These are for major variations. There is one report, so the report applies equally to both hearings in terms of the process and the procedure, but we'll deal with them in turn. Firstly, Tina Mara first, and then secondly, Sambuca. Just talking about the procedure, as required, a copy of both applications was sent to the relevant organisations at paragraph 2.2, and we have also checked compliance with the notice period. Confirmation of site notice has been received for both applications. And again, in terms of determining these applications, decision for the members is whether to grant or refuse, and the individual decision is obviously needed in respect of each one. If no ground for refusal applies, then the board must grant the application. If any ground for refusal applies, the board must refuse. Grounds for refusal are set out at 3.3. They are, as I've said in the previous item, whether there's been an identical variation request refused in the preceding 12 months. Secondly, if it's for 24-hour operation and there's no exceptional circumstances, or whether the application is for off sales prior to 10 AM or after 10 PM. The other grounds for refusal, as before, are whether granting the application would be inconsistent with any of the licensing objectives, whether the premises are unsuitable, having regard to the nature of activities, location, character, or condition of the premises, or the persons likely to frequent the premises. And lastly, if the board considers if the application was granted, there would be over provision. In terms of procedure, we would hold these hearings separately in this item. First is T. Namara, and we do have Neil Fisher, who is the licence holder, attending by Teams. We also have LSO Julia Farrell. We also have Amy Ritchie, Sergeant Ritchie from the police today. Suggest that we allow perhaps Sergeant Ritchie to say if there aren't any objections. We should say there might not be anything, but the police can confirm that. LSO can speak to the report and be asked questions. Neil Fisher, for the applicant, can then speak to the variation and be asked questions, and then we can sum up and then go into session.
So, Sergeant Ritchie, anything you want to add to this report?
Thanks, Convener. No, there's no police objections and no concerns from us. Thank you.
Ms Farrell, would you like to take us through your LSO report, please?
Yes, good morning. Thanks, Convener. So this application is in relation to the Tainamara, which is located in the village of Sandhead. It's a popular restaurant within the village and indeed within the surrounding areas. It was transferred in August of this year, and there's been significant investment put in with improvements made to the premises to a very high standard. The main reason behind the application is the bedroom at the rear of the premises and the TIG to go outlet, which is a popular takeaway provision. So they do deliveries and you can collect, and it's becoming an increasingly bigger part of the business. So previously the bedroom and the outlet was out with the licensed area. So the application will encompass both into the licensed area and will increase the outdoor drinking area if it's needed during the summer when it's very popular. The applicant at the same time took the opportunity to change the admittance policy for children and young persons just to bring it in line with the board's current policy, which is very welcome. The notice was displayed in the window of the premises, and I've got no adverse comments to make at all in respect to the application. Thank you.
Thanks for that. Are there any questions for Ms Farrell? Don't see any hands going up, so we'll move on now to Mr Fisher. If you'd like to address the board with regard to your application.
Hello there. How you doing? Yeah, like Julia said there, we've been established for over 20 plus years, and now I'm at the helm of the business and looking to take it forward for the next 20. And these changes obviously come in line with modern practices with the young children, the Tig2Go new business, the takeaway, and it just making sure that we are covered for all these avenues. So hopefully you find that favourably in our behalf.
Are there any questions for Mr. Fisher? Don't see any hands going up. Similar to the last one, you have the right to sum up, but I don't know if there's anything you want to add to your presentation.
To be honest with you, we've been on the go for quite a wee while now, and it would be beneficial, obviously, to have these items approved today to let us continue serving the local community.
Right, we're now in session. Over to members. Councillor Dryborough.
Yeah, I think we should agree with the recommendations of granting the licence.
Is anyone otherwise? Oh, Councillor Howie.
Happy to second.
Right. Is anyone otherwise minded? No hands going up. Take that a unanimous decision of the board is to approve the. It's a major variation. Yep. Excellent. Mr. Tom, could you just relay that to the applicant?
Thank you, Convener. Yes, the unanimous decision of the board is to approve the major variation. Mr. Fisher, that's us concluded. You'll get written confirmation of that, and you're free to go if you want.
Excellent. Thank you very much. Thank you. Bye-bye.
We'll now move on to the second hearing, which is for Sambuca. Mr. Tom, if you'd like to address us in this one.
Yes, so it's the same, essentially the same process and the same grounds for refusal, if any. In terms of who we have today, again, I think we have, we can check first of all with the police, Sergeant Ritchie, if there's anything on their end, although there's no objection been noted. LSO for this matter is again Julia Farrell, who can speak to her report, be asked questions. The applicant, we have Samantha Priest, who is on online on Teams. Again, she can be asked to speak to the variation sought and then be asked questions, sum up if any, and then go into session for a decision.
Sergeant Ritchie, anything you want to add to this report?
Nothing to add, thanks, Convener.
Ms. Irvin, would you like to take us through your LSO's report, please? You're on mute yet, if you...
Sorry about that. Thank you, Convener. So members may be aware that the applicant Samantha came in front of the board in July this year for a major variation when she took over Nico's restaurant in Castle Douglas, which thereafter changed to the Olive Retreat. The premises sadly had a kitchen fire 5 days later and closed. I spoke to Samantha about alternative premises, however there was nothing suitable as takeaways were her primary request. The premises here today were identified, though takeaways were not included in the existing operating plan. The variation is primarily to permit takeaways, and the other changes are to fully comply with her requirements. The notice was displayed with no issues. All the variations are within the board's policy. I have no negative comments. Thank you.
Are there any questions for Ms. Irvin? Don't see any hands going up, so Ms. Priest, would you like to address the board on your reason for your application? Speak to your application.
Hi there. Yeah, really, it's just to kind of optimise the business. We did a good takeaway trade down at the Olive Retreat, and it's really part of enabling us to survive on the high street. with all the additional overheads. So we really need to be a busy business. We have opened as a restaurant up the road, and you know, it's been really welcomed by the local community, as they said that they've really not had much options throughout the summer. So it's going well so far, but yeah, I kind of need the added variations to the license to kind of make it a success.
Are there any questions for Ms Priest? I don't see any hands going up. Similar to the last one, you have the right to sum up, but if you've nothing else you want to add to it, then we'll just go into session. But Ms Priest?
Just want to say thank you to the licensing team, really, who have supported me through like this struggle since July. They have been really helpful when, you know, I've needed advice, needed support with, you know, looking at the applications, etc. So yeah, just to show my gratitude really to the council's team.
Right, yeah, thanks. We'll move into session now. Being asked, Councillor Dryborough.
Yeah, I think we should grant the application, convener.
Is there anyone otherwise minded? Take it that's a unanimous decision of the board that we grant the application. Mr Tom?
Thank you, Ms Priest. The board's unanimous decisions to grant the variations sought, so you'll get written confirmation of that, and that's this matter concluded, and you can go if you'd like.
Thank you very much. Bye.
Right. Move on to item 7, Licence in Scotland Act, personal licence application, Mr James Reid. This item is for dealing with an application for personal licence. I think there's a preliminary issue to start with, but Mr Tom will keep us right on that. Mr Tom?
Thanks, convener. So yes, council received an application for a personal licence. The Chief Constable submitted a notice stating that the applicant has been convicted of relevant offences, but there is no objection from the police. So the board doesn't have to hold a hearing. So the preliminary thing for members to decide at the moment is whether the board wishes to hold a hearing, and that would be with a view to conducting further inquiry from either the police, or we do have the applicant online today. So the only decision at the outset is whether to hold a hearing or not. If you don't want to hold a hearing, you're effectively saying you're happy to decide it on the papers, and you would be granting the licence at that point. So if you want further inquiry, you would want to decide to hold a hearing, and if you do decide to do that, I can tell you what process I suggest.
Councillor Dryborough?
Yeah, thanks, convener. And, you know, I think everything that we need to know is actually in the papers in front of us. The police have not formally objected to this. And, you know, Mr Reid has, you know, clearly stated he made a mistake, and, you know, the police are happy with that. So I would suggest that we don't hold a hearing and grant the licence.
I was similarly minded as yourself, Councillor Dryborough. Is there anyone otherwise minded? Councillor Thompson?
No, sorry, just a bit late with my hand. It was just to agree with Councillor Dryborough. Thank you.
Right, if there's no other person wanting to speak, I think that's a unanimous decision that we don't hold a hearing, and the information was enough to allow us to determine the application in favour of Mr Reid.
Thanks, convener, and Mr Reid, I see you on Teams. The board's unanimous decision was that a hearing was not required, which means the licence will be granted. So thanks for coming, Mr Reid. You won't be needed to say anything, and you'll get written confirmation of your licence in due course.
Thank you. Yes, bye-bye.
And we'll now move on to item 8, review of personal licence, Mr Lee Palmer. This one has been before the board before. Mr Tom, can you take us through the procedure today?
Thank you, Convener. I think just at the outset we did receive some contact by telephone that Mr. Palmer had intended to attend by telephone, but I just wanted to check that he's not dialed in. I don't know if we've got anything. He's not made any contact, so I suppose first of all, before we go any further, if we should decide if we're content that he's had opportunity to attend and we're happy to proceed in his absence at this point, that would be a good idea. Just in terms of procedure, I can advise this is a matter that's been deferred before, so Mr. Palmer didn't attend at the previous hearing on this matter on the 18th of September, and since then, on the 22nd of September 2025, a letter and email were sent out to Mr. Palmer with the board decision and a new board date, which didn't receive a response. On the 20th of October, he was again emailed with no response. On the 22nd of October, he was phoned and left a voicemail. He didn't get in touch after that. On the 30th of October, he did make contact, so that was just today, saying he was attending. Yesterday, sorry, so it was the 29th of October, sorry. He did say he intended to attend by telephone, but he hasn't made any effort to do so. There's been no contact today about that, so that's the factual background. We do have a phone number for him and an email address on record.
Right, members, we've heard from Mr. Tom. We had this before us last month, and I think the sort of letter that went out did say that we would possibly hold it in his absence this time, or would consider it in his absence. Are members happy to continue? Councillor Dryborough?
Yeah, I mean, he's had his opportunity, Convener. I think it's right that we hold the hearing.
Don't see any hands going up, so I take it that everyone's in agreement with that. So the procedure today, Mr. Tom.
Thank you. So this is a matter was deferred from a previous hearing, as I've said. A report from the Chief Constable was received in terms of Section 84A, which is with your papers. That is why a hearing must take place to consider it. Essentially, the view of the police is that Mr. Palmer, in their view, has acted in a manner which is inconsistent with licensing objectives, and that's set out in their letter as to why. As I say, it's been deferred. He's not here. You've decided to hold the hearing in absence. In terms of moving forward today, the options for members are to consider and agree whether to revoke, suspend, endorse the licence or take no action, remembering that if you decide, based on the evidence you hear, that the licence holder is not a fit and proper person to hold a personal licence, then the only thing that the board can do is revoke. So if it's to do with the licensing objectives only, you have options to revoke, suspend, endorse or take no action, but if you decide he's not a fit and proper person, then you can only revoke. In terms of procedure, we would normally ask the police, Sergeant Ritchie, to speak to the letter that's been submitted by the police. She can be asked questions. The applicant, the licence holder, sorry, is not here, so you can't ask him any questions, so you would simply be asking questions of the police and then going into session after that. The police, of course, could sum up after you've questioned them.
Sergeant Ritchie, would you like to speak to your report?
Thanks, Convener. So, yeah, as outlined, this is a report of conduct inconsistent with the licensing objectives, and those relate to preventing crime and disorder, securing public safety and preventing public nuisance. The circumstances that gave rise to this are about 6 o'clock in the evening on Saturday the 19th of July. 3 persons entered the Imperial Hotel and Bar in Castle Douglas, whereby Mr. Palmer works. On entering the bar area, a heated discussion has taken place between bar staff and the three persons with regards to whether or not one of the group was allowed entry. Following this, the three persons left the premises and upon exiting observed one of the bar staff, Mr. Lee Palmer, standing in the doorway in possession of a metal bar, causing them fear and alarm. The matter was subsequently reported to us and inquiries were undertaken which confirmed that the incident had been captured on CCTV. Thereafter, on Sunday the 20th of July, Mr Palmer was cautioned and charged with a contravention of Section 38 of the Criminal Justice and Licensing Scotland Act, which is threatening or abusive behaviour, and a contravention of Section 47(1) of the Criminal Law Consolidation Scotland Act, which is possession of an offensive weapon. As the matter sub judice at the moment is a pending case, I'm unable to provide any further information, and I can confirm that we checked this morning and there's no update with regards to the court case in respect of that. So in our view, the conduct displayed by Mr Palmer during this incident falls far below the standard reasonably expected of a personal licence holder. The behaviours were directly connected to the sale of alcohol in the course of his role as a personal licence holder or bar staff. And there are now concerns surrounding an apparent propensity for violence and his ability to uphold the licensing objectives. And in our view, he's potentially no longer a fit and proper person to hold a personal licence, and we have suggested consideration of suspension. Thank you.
Any questions for Sergeant Ritchie? Councillor Howie?
Sergeant, all we have in front of us, obviously, is that he was in possession of a metal bar. Is there anything to suggest that he aggressively approached the complainers in this case? Did he make any threats of violence? Was the bar raised above his shoulders, or was he merely in possession of it?
Thank you, Councillor. So he was in possession of it, but my understanding is that he's followed these three people out to the bar entrance or the doorway, and obviously that's been sufficient to cause these persons alarm, but nobody's been assaulted or injured.
Thank you.
If there's no further questions, do you wish to sum up?
Convener, I think I've covered everything, but obviously the incident is directly connected to the sale of alcohol and does raise concerns surrounding his conduct and ability to uphold the licensing objectives. Thank you.
Members are now in session. Councillor Dryborough.
Yeah, thanks, Convener, and we've given him an opportunity to come back to the licensing board, and he's shown a bit of disrespect there. I think even not answering the emails and letters from the licensing department. So I would suggest that because he's shown disrespect to us and he's shown disrespect to the licensing department, that we revoke his licence as suggested in the papers.
Right, and that'll be on the grounds that he's not a fit and proper person.
That's correct.
Right. Councillor Thompson.
Yeah, thanks, Convener. So I'm still not 100% sure whether or not he's a fit and proper person, because I'm not clear that this is isolated, what the full context was, etc. But clearly, some action needs to be taken. And are there other reasons why a licence may be revoked if we think that this is not appropriate in terms of public safety? All the other acted in a way that's inappropriate for licence holder, etc., but may not necessarily mean that he is intrinsically not a fit and proper person. So I'm just trying to find I'm certainly happy to take action on this one, but to say not a fit and proper person basically rules out any, that person would no longer ever be able to have the licence, presumably. So maybe I could get a bit of advice from the officer, if that's okay, just on that one. Thanks, Convener.
Mr. Tom.
Yes, thank you, Convener. Yes. So this is, I suppose, a more a general point for giving reasons for any proposed decision, whether it's revocation, suspending, or endorsement, or taking no action but finding the review ground upheld, you have to tie it back in. My advice is that you have to tie it back into a relevant licensing matter. So I'm not saying there's never a world where showing disrespect, if that's your decision, to the licensing board or any officer wouldn't be a relevant consideration for fit and proper person, but generally fit and proper person relates to normally criminal conduct, but otherwise unwanted conduct that relates to their licensed activities. Now, I'm not saying it's not you can't exclude it, because you could take the view that participation in licensing board practices is something that's expected of a responsible fit and proper license holder, but generally speaking, you would be looking at the complained about behaviour, which is what the police are asking you to focus on, and that's the alleged criminal conduct that they're speaking about. So revocation is obviously the most severe outcome. Revocation takes effect after a 28-day period following an appeal allowance. There's a 28-day period in which anyone whose licence has been revoked can appeal. Suspension is for a maximum of 6 months, can take place with immediate effect, and it is worth pointing out, since Councillor Thompson asked, that the difference between revocation and suspension is indeed that revocation is a more serious matter, whereas suspension would be deemed a slightly lesser sanction. Trying to answer the whole point, sorry, I'm just trying to think if there's anything I haven't answered before we move on. I think I've covered it. I would just recommend you give reasons. You give reasons for any decision. If you're revoking the licence, it doesn't have to be on the ground of fit and proper person. But if you decide he is not a fit and proper person, you must revoke. Sorry if that's cyclical in some way. You can revoke in other circumstances, but if you decide it's because of fit and proper person that's triggered here, you must revoke. You don't have the other options open to you. I hope that helps.
Councillor Thompson, would you like to come back in on that point?
Yes, thank you, convener, and thanks. Thanks. I think it was the last part there. It was just really one necessity. So if it's not fit, somebody's not fit and proper, you must revoke. But we could revoke for other reasons, basically. I mean, I'm minded to take into account the preventing crime and disorder and securing public safety, etc. At the start. I'm conscious, though, that this is still sub judice, and I would be more comfortable at this point, even though there is kind of like the person's not turned up for whatever reasons on the number of occasions. I'd feel safer at this point to suspend it until we know the outcome of the court process, because at the moment it's sub judice, and then make sure that it comes back, so that we're, I suppose, minimising any risk given the evidence that we've got in front of us. And then, but at this point, it would just be on those grounds of public safety, and just to allow that process to conclude. And I don't know if that's, it may end up that we revoke it anyway, or whatever. But until that's, I'd want to be seen to be being as fair as possible with this one. Thank you.
Mr. Tom, can you just clarify, if this were to be called to court in 7 months' time? I've maybe read the papers wrong, but my understanding is the maximum suspension is 6 months. So could we do that? And if we do suspend, do we have the ability to recall this one if it was found guilty, because of the fact that it would be like double jeopardy? We've already heard this one.
Yes. So what you don't have as a board is a power of interim suspension. So you are being asked to fully decide today. So my advice would be that if you were to suspend today, it would be possible for the Chief Constable to bring it back for review if there was a conviction, but you'd essentially be being asked to decide on the same conduct. The only The only, I suppose, material difference at that point could be depending on what sentence was imposed if he was found guilty or pled guilty, because it's the conduct that the police are complaining about, and that's what you're being asked to take into account. You're not being asked to take into account any criminal sanction. You're being asked to take it not at face value, sorry. You're being asked to accept the police's account that they are satisfied that he has acted in the way they've stated with the metal bar, and that's why he's been charged. So it would be, it's up to members to decide, but it would you can't impose, in my advice, an interim suspension. It is a final decision you're being asked. It is possible. If you don't want to make a final decision today, you do have the option to defer pending the outcome of proceedings. You've heard what the police have to say about that. The matter doesn't seem to even be before a court at the moment, so there wouldn't be a time scale based on my knowledge of time limits. These offences are indictable offences, so there is no hard and fast time limit for which they have to come to court. So there would be no guarantee, well, and my advice would be there would be no guarantee that the matter would be heard and concluded within those, I was about to say within 6 months. You do have the power to indefinitely defer this to a point, obviously, as long as there's a reason for deferring. So suspension is a final outcome. You can't interim suspend. You can defer if you want to wait for the outcome of the criminal proceedings, but you would be doing nothing in the meantime with his licence.
And thanks for your patience, Councillor Howie. Councillor Howie?
Thanks, Convener. Very much the same as Councillor Thompson. We don't know what the outcome of any criminal trial is going to be on this, even if the fiscal is going to take it. So on that basis, I'm certainly not comfortable to the extent of revoking. I'd be a lot more comfortable suspending. And on that basis, if that's what Councillor Thompson is putting forward as a motion, I'm quite happy to support it.
Right, with Councillor Thompson.
Yeah, so I'm sort of caught in betwixt and between, as it were. But can I just ask another little bit of advice? So if we were to revoke, given that there's clearly been an identified inconsistent behaviour from the police about preventing crime, securing public safety, preventing public nuisance, but if a licence is revoked but somebody's not deemed to be not fit and proper, is there? And given the length, given that we don't know what the court process might take, and also in the advice that it's not so much the conviction that's the issue, it's the behaviour. Is there can somebody, what avenue is open for a person to reapply once their licence is revoked, but they're still effectively fit and proper? So it's just to get a sense of what avenues are available, because I think we already are aware, as Councillor Driver pointed out, the person has not turned up given more than one opportunity. So there may be other reasons for that, but surely if the person's still fit and proper, they could reapply, and then that would obviously demonstrate the relevant motivation that they still want to be a licence holder, but they weren't excluded from it, if that makes sense. So it's just to bottom that one out, if that's okay to yourself, Convener.
Mr. Tom, there used to be, going back a few years under the old Licensing Act, if someone was coming back within a year, there was a paragraph in the law that you could exempt it so that you could actually hear the case. I don't know if that was carried on to the new one. Is there an opportunity for something like that if found not guilty or not taken to the court? Would there be an opportunity to come back within a year?
My understanding, and I'll be corrected if I'm wrong, that if you choose to revoke this personal licence, that revocation takes effect for a period of 5 years. So it's got quite severe implications. You're effectively barring someone from holding a personal licence for 5 years. If you revoke, suspension doesn't come with that outcome. So revocation is very much the most severe, and that would be the impact. You would be revoking, and the revocation would stay on record, have effect for 5 years.
Councillor Lowe.
I would agree with suspension on the grounds of public safety, and because basically the criminal process is the process is not yet complete. So to the 6-month suspension.
Right, so let's try and pull this together. We have Councillor Driver who would like to go for revocation on the grounds of not fit and proper person, and 3 other members, I'll let them speak for themselves, but I think Councillor Howie and Councillor Lowe were definitely on the grounds of suspension. Councillor Thompson, you mentioned revocation as well, but there was additional information came back that might or might not have changed your mind. So, Councillor Thompson.
I mean, it'd be interesting to hear if there's any other views, but so I think I'm just not convinced that we've got enough in front of us to say the person's not fit and proper. So I'd rather rule that out. That's just my view. But I'm not comfortable as well that the suspension, we're sort of limited to 6 months and a revocation is 5 years. So there's sort of nothing in between. So I think it's one of these ones where, you know, if the fairest way to go forward is to suspend and see what the outcome is, and there's always room, I suppose, for hope and improvement in terms of people's training and sort of learning, then if something happens, I just don't want to feel that we're taking an unnecessary risk by not revoking something, and then if the person's really motivated by coming back. So it's a bit of I'm kind of caught between, but I think suspension might be the fairest given what we've got in front of us. That's not very helpful, is it?
It's yes, it's helpful. So going by that, Councillor Howie and Councillor Lowe had intimated that they were willing to go for suspension, and Councillor Thompson's looking that way as well. Councillor Dryborough?
Yes, I've listened to what other members have said, convener. That's me on my phone now, heading up for my inoculations. I think, listening to what other members said, I would rather go for suspension now. Then at least we've got this will end this one, and hopefully he'll not come back.
Right, we are. So that's, I think everyone's sort of moving towards suspension on the grounds, I think Councillor Lowe said, was it preventing crime and disorder and securing public safety? Was that the 2 grounds I think they mentioned? Don't think they had the 3rd one in.
That's what I'd noted.
Yeah. So if we're all minded to suspend, do we need to have a separate vote on the period of suspension?
So yes, you need to decide on the length of the suspension up to no more than 6 months, and you would want to clarify whether that suspension's to take effect immediately, which is within your power to do.
Councillor Dryborough?
Yeah, I would say up to 6 months.
Well, so with immediate effect?
Yes.
Right. Councillor Lowe?
Councillor Driver beat me to it. 6 months, immediate effect.
Councillor Thompson?
Yeah, I'm happy with that as well. 6 months is the max, and also I just wondered as well, you know, that we are also able to endorse. Is it an either or can we do both? So because I think there is a concern here that this is, you know, this type of behaviour is completely not appropriate. So is there something that would encourage the applicant, the licence holder to, you know, to try and improve their behaviour or take necessary steps to give that assurance?
I take it that the suspension will be noted on his record. So would an endorsement add to it, or just be a sort of belt and braces procedure?
Well, I'm trying to think. I think it's competent to endorse and suspend. The only thing I would add about endorsement is that there is a procedure if there are 3 endorsements made in respect of a licence, then that triggers a hearing being fixed. So I suppose you'd want to have a reason for doing both, but if the reason for, one reason for doing both, which you might or might not accept, is that the endorsement, which is live for 5 years, obviously a suspension expires after 6 months, that there is it would trigger a hearing if there were 3 endorsements made on someone's licence. Now, in practice, the endorsement only happens, the endorsement's only really going to happen when it comes back, if it came back for a hearing anyway. So it's whether you think that that's necessary, because I wouldn't ever preempt a decision, but if you clearly the suspension will be noted in any future proceedings, and that might do the job of the endorsement, if you like. But it's open to you, in my opinion. You would just want to give a reason why you were endorsing as well, and potentially a reason to endorse as well is that it remains live for 5 years, and there is a process for 3 endorsements triggering a hearing.
Councillor McCammon, and then I'll come back to Councillor Thompson.
Yeah, thanks, convener. Yeah, I wouldn't be for both. I would be for, if it's possible, for the suspension alongside, and I know it's not a legality as such, but maybe alongside a note from the board. Would that be possible?
So it is. If you want anything in particular, obviously there would be written confirmation of any outcome, and if the board wants any particular thing conveyed in that written communication, it absolutely could include that, and happy to include any wording that the board decides.
Councillor Thompson.
Yeah, no, thanks for that. And I think that's. I mean, that feels like a sort of a better way to go forward. So, I mean, I would support if everybody else is minded as well what Councillor McCammon's saying. So, rather than an additional endorsement, which we may consider if it comes back, the suspension's probably, that gets recorded anyway, and then a letter to the effect. I mean, certainly about upholding the licensing principles and sort of what good behaviour looks like, and sort of avenues for support or training, whatever it might be that could encourage good behaviour and help the licence holder do that, then I'd certainly support some kind of letter. But recognising that it's not an official sanction or whatever. So, but I think that would help add to the message we're trying to give out. Thank you, convener.
Right. With that, I think we have a sort of unanimity there that we suspend the licence for 6 months with a letter on the grounds that Councillor Thompson has highlighted, noting that we would expect improved behaviour, and this is what we would expect as a board of a personal licence holder. Members happy with that?
Yep.
No one otherwise minded. Mr. Tom, for the record, please.
Thank you, convener. The board's unanimous decision, having decided that the licence holder has acted in a manner inconsistent with the licensing objectives of preventing crime and disorder and securing public safety, have decided to, with immediate effect, suspend the personal licence for 6 months, and for the letter that communicates that to go to include reference to the board's expectations of improved behaviour, and that will be done.
Right. With that, I have no further business. Next meeting is the 3rd of December. Can I thank you all for your attendance?
Thanks, convener.
Thanks, convener.
Thank you.